This began, members, with incidents of the summer of 2012, when, due to probably lack of oversight on our part as the legislature, the city of Minneapolis was forced to disclose over 2 million license plate images to members of the press and other individuals, disclosing the location, whereabouts of individual innocent citizens. That was shored up by a temporary agency designation that it had been private, which currently holds, but something will still need to be done about that this legislative session. Since the end of that last legislative session, when nothing was done about that, we had the NSA disclosures, which gave rise to more citizen interest in surveillance of individuals in the Republic. And of course, that spurred on the investigation done by certain citizens about the use of kingfish and stingray, which was the impetus for calling this hearing, but it is not. This hearing is not solely about kingfish and stingray. It is about government surveillance in general. Before we begin, I want to introduce the committee's new committee administrator, Emily Lepples, who has taken over from Charlotte Anton DiGiulio, who many of you know sat here but recently moved on to greener pastures and did an outstanding job for this committee. So if you know Charlotte and worked with her, send her a note and congratulate her on her greener pastures. This oversight hearing is intended to hear from policymakers. The committee is interested also in hearing from other individuals, including administrators of these programs, individual bureaucrats or lobbyists. That's important, but the committee cannot hold those individuals accountable for their answers. For an oversight hearing, we can only hold accountable policymakers, which is why we invited police chiefs and sheriffs mostly, as well as our friends here from the Department of Public Safety. So that is why the list invitations went out. To the extent that we are able, and time permitting, we will also hear from members of the public. The other individuals we will hear from are advocates for privacy interests, and the reason for that is to set the stage for objections to current uses of some of these technologies to better frame the question we're going to be talking about in front of the committee. The parameters of this oversight has been questioned, and I will make clear that with respect to local units of government, this committee has oversight jurisdiction. In the United States Constitution, there is no separate provision for local government. These powers vested either in the federal government or reserved to the states. The states may delegate law enforcement authority to local units of government, sheriffs, police chiefs, etc., but we cannot delegate the oversight constitutionally. So with that, I will first ask ACLU Legislative Director Ben Feist and ACLU privacy expert Kathleen Crump to please come to testify today. And please introduce yourself for the record and begin your testimony. Members, as they're preparing, we will entertain questions throughout this testimony, but in the interest of time, because we are going to shut down by noon, in the interest of time, I may ask you to aggregate your questions, or maybe even take some answers offline. With that, Mr. Vice, please proceed. Mr. Feist.
Mr. Chair, members of the committee, my name is Benjamin Feist, and I'm Legislative Director of the American Civil Liberties Union of Minnesota. The ACLU of Minnesota is a nonpartisan, nonprofit organization dedicated to protecting the civil liberties of all Minnesotans under the United States and the Minnesota Constitution. We have 8,500 members throughout Minnesota and promote our mission for litigation, public education, and lobbying efforts.
Thank you, Mr. I'm not sure that your mic is on, or I'm not sure that it's loud. Either if you could bring it closer to you, or somebody could turn it up.
Thank you, Representative Bostrom. Can you get a... Thank you, Mr. Feist. Please proceed.
Thank you for the opportunity to participate in this important discussion today on emerging technologies and privacy rights. I look forward to working with members on specific bills and pieces of legislation that will be coming up in the new session. But today, I am really here to introduce my colleague from New York, Catherine Crump, who has braved the Minnesota winter to join us today. Ms. Crump is a staff attorney with the National ACLU Speech, Privacy, and Technology Project, where she litigates First and Fourth Amendment issues. I'll now turn it over to Ms. Crump. Thank you.
Thank you, Mr. Price. Ms. Crump.
Mr. Chairman and members of the committee, it's an honor to be here with you today. I very much appreciate the committee's interest in these important topics. Today, more than ever before, the American people are not only aware of the way that law enforcement agencies are using increasingly advanced technologies, but also concerned about much of what they are learning. While the most prominent example of this phenomenon is the National Security Agency's mass collection of every telephone call that we all make, the records of those calls, there's no question that similarly powerful technologies are being used at the state or local level. That is because that the same technological trends, which now allow the mass collection of people's call records, allow technology to be cheaper than ever before, and so local law enforcement agencies, which could never previously have afforded such powerful tools, now have ready access to them. The ACLU is not opposed to the use of modern surveillance technologies by law enforcement. Far from it. The job of law enforcement is vitally important. It keeps us all safe, and they should have access to the most important tools. That said, so we're not against the use of these technologies. I would like to say, however, that there's an important question about what standard applies when law enforcement wishes to take advantage of these technologies. We think that standards for invasive technologies need to be rigorous, often involving court oversight, so law enforcement agents need to make their case to a court that a particular search is based on probable cause. We think that it's important for there to be rigorous standards in place, such as the probable cause standards, which, as you all know, derives from the Fourth Amendment of our Constitution. There are many novel surveillance technologies that we could discuss in today's hearing, but to give my remarks some thematic coherence, I've decided to focus on 4 technologies, all of which implicate Americans' right to travel free from government surveillance. But of course, if there are other technologies members of the committee would like to discuss, I would be happy to address them too. So I'm going to focus on 4 technologies. GPS tracking of vehicles. It is now possible to attach a GPS device to a car or another vehicle to track its movements. Cell phone location tracking. The use of automatic license plate readers, which I may touch on only briefly given this committee's deep familiarity with that technology. And finally, and perhaps more futuristic issue, the use of surveillance drones by law enforcement agencies. But before I dive into the particular technologies, I would like to quickly make the point that where people travel can reveal a great deal of personal and private facts about them. You don't have to take it from me. I would prefer a quote from one of our Supreme Court justices, Justice Sonia Sotomayor, who wrote that at least in the case of GPS tracking someone's movements can reveal trips to the psychiatrist, the plastic surgeon, the abortion clinic, the AIDS treatment center, the strip club, the criminal defense attorney, the by-the-hour hotel, the union meeting, the mosque, synagogue, church, gay bar, and so on. And so although one might think that movements in public aren't private because you are in fact out in public where other people can see you, if you track someone, particularly over a prolonged period of time and in sufficiently granular and detailed ways, you can learn these private facts about them. The Supreme Court, Justice Sotomayor made that point in a Supreme Court case called United States versus Jones. In that case, law enforcement agents attached a GPS device to an individual's car and tracked that person's movement for 28 days without a valid warrant. The Supreme Court held that under the Fourth Amendment, that tracking constitutes a search precisely because of the types of information that can be revealed by the prolonged tracking. However, the Supreme Court left unresolved 2 key questions. First, whether GPS tracking is the type of search that triggers probable cause, or whether, for example, an officer's belief that he has reasonable suspicion that someone is engaged in wrongdoing is sufficient. And by the way, I think this distinction is crucial because if you need a probable cause, you need to go to a judge, and I think the practice of needing to articulate why you are carrying out a search is perhaps the most important constitutional safeguard there is. And number two, the Supreme Court did not resolve the question of whether other surveillance technologies such as GPS tracking, drones, license plate readers also implicate the Fourth Amendment. It will take the Supreme Court many years, if frankly not decades, to resolve these questions. After all, the Supreme Court did not decide until the late 1960s that the government needs a warrant based on probable cause to listen into the content of Americans' telephone calls. Justice Alito, in his opinion in this very same case, suggested that the complicated types of issues posed by current surveillance technologies were far better addressed by legislatures in the first instance than by courts who have to adjudicate on a case-by-case basis. So rather than sitting back and waiting for the court system to resolve these issues, I think it's important that bodies such as this one address them in the first instance, and that's why I'm so heartened to be able to be here today testifying at this hearing. So we talked briefly about GPS tracking, the form of technology that was addressed in the Supreme Court's decision in the United States versus Jones. I will just briefly talk about the technology. It is now possible to have a device, a GPS device, which you can physically attach to a car and track its movements for as long as you like. One of the significant developments about this is that it has substantially reduced the cost of surveillance. It used to be exceedingly expensive to track someone 24 hours a day because you needed teams of agents in order to do that. And practically speaking, one of the primary constraints against excessive government surveillance has often been the cost of that surveillance. But now, as technology has made surveillance cheaper than ever before, it is more important that there be legal restraints in place to ensure that legitimate use of law enforcement technology can go forward, but that this technology is not abused. GPS tracking by attaching something to a car is one way you can engage in GPS tracking. But if your car has a built-in navigation system, for instance, the system that says go left here when you reach a corner, the law enforcement is also technically capable of tapping into those systems, which helps the companies in tracking them that way. So it may not, in fact, even be necessary for law enforcement to go through the time and effort of attaching a GPS device to a car in certain circumstances. Cell phone tracking. Of all of the privacy issues we're currently addressing, I think this is one of the most significant. Americans, today virtually every American carries a cell phone with them. I doubt that there's a member of this committee who doesn't have a cell phone, although I suppose I could be surprised. I've been working in this particular area for 10 years, and when I used to go speak with people about cell phone tracking, I would ask people to raise their hand if they didn't have a cell phone, and I've stopped doing that exercise anymore because no one raises their hands. We carry our cell phones with us wherever we go, in our pockets and purses. We even often sleep with them by our bedsides. So because cell phones are not just devices to make calls, but increasingly sophisticated tracking technologies, the ability to tap into and track cell phones is a way, particularly as technology continues to advance and tracking location through cell phones becomes more precise, that individuals can be tracked in great detail. Now, there are many different forms of cell phone tracking. It is possible with the cooperation of the carrier, the cell phone carrier, Verizon, AT&T, and so forth, to get both historical and real-time information about people's movements. The least precise form of cell phone location data is called cell site location information. This data is generated because every time your cell phone is turned on, in order for the carrier network to be able to route calls to your cell phone, the carrier the phone automatically pings cell phone towers in your vicinity. And because cell phone towers have a known geographical location, this cell site location data is an increasingly accurate proxy for your location. I say increasingly accurate because as people use their cell phones more and more, and as cell phone usage becomes more data intensive thanks to the development of smartphones, cell phone carriers have had to build more and more towers. And as tower networks become ever denser, cell phone tracking through this technique becomes more and more precise. In addition to cell site location information, it is possible to get even more accurate information on people's movements. Many cell phones now, particularly smartphones, have built-in GPS hardware that allows technology to allow cell phones to be tracked through GPS. But even if that technology isn't present, it is often possible to triangulate the location of the cell phone by calculating things such as the angle at which it is communicating with various cell phone towers to get a more precise read on its location. I don't know about your memory of junior high school trigonometry, but that's the general idea. So as I mentioned, cell phones can be tracked both in real time, but carriers also retain historical data on where people have been in the past. I don't think most Americans are aware of how long carriers keep records of where they've gone. In some sense, I think the historical data is even more sensitive than the real-time tracking. While it may seem invasive to know that law enforcement agents are monitoring your every move, historical data can stretch back for years. So in that sense, it can be quite revealing. So just to give you some sense of how long these records are kept, Verizon, at least according to the most recent data I've seen, which dates back to 2010, I believe, which is quite some time ago, the carriers aren't particularly forthcoming about how long they store this type of data on Americans, perhaps because they think Americans may find it invasive or privacy invasive to know that their every movement is being tracked by the companies that they give money to. Verizon stores cell tower records for one rolling year. T-Mobile keeps this information for, quote, officially 4 to 6 months, really a year or more, and I'm quoting from a Department of Justice document. And Sprint and Nextel store the data for 18 to 24 months. AT&T and Singular, at least in this 2010 document, have stored data since 2008. So you can see how by obtaining historical information, you can get information on people's movements stretching back not just days or weeks, but months or possibly even years. So law enforcement can obtain cell phone records for one individual stretching over a period of time, but it is also possible to obtain data on large numbers of people who are in a particular geographic area. If, for instance, law enforcement agents were to go to a phone company and obtain an order to obtain a tower dump for the cell phone tower closest to this hearing room, law enforcement agents would get, if they accept folks brought their cell phones, would be able to get all of our cell phone, would know from that all of our cell phone records as well, at least to the extent we've made phone calls or sent text messages or access to the internet using our phone. Tower dumps obtain large quantities of information, not just about one individual who's under suspicion, but a larger group of people who happen to be in a particular geographic area. And I think for that reason, they pose particularly serious privacy risks. Again, no one is arguing that it is inappropriate for law enforcement to ever access this information, but because of the sheer number of innocent people whose records are affected, we think it is important that law enforcement agents obtain a warrant based on probable cause for this type of information in particular. And as this committee is well aware, law enforcement can also, in certain circumstances, obtain information about cell phone location without the help of local carriers using the aptly named Stingray device. There's a whole series of these devices. They all are named after different types of fish. There's a triggerfish also. And this can allow law enforcement agents to, for instance, tell that a particular cell phone is located within someone's home. The home, of course, being traditionally one of the most protected areas in our Fourth Amendment privacy tradition, or to determine all cell phones in a particular geographic region. So that's some of the background on cell phone technology, and I hope that by relating some of the facts about the granularity and type of data that can be obtained, that I have done some work to convince you that this information is sensitive and rigorous standards should apply. I'll move on now briefly to automatic license plate readers. As you all are well aware, these are devices which take photographs of every passing car and can capture the license plates in them. The ACLU does not oppose this technology either. It is an efficient way, for example, to check plates against lists of cars that are associated with being stolen or perhaps associated with individuals who are wanted for arrest. Our concern, however, begins when law enforcement agents keep data not only on individuals where there's a hit for their car, but on all innocent people. We have done extensive public records work actually all around the country in 38 states to try to obtain information on how this plate data is used. And given that the vast majority of American people are not engaged in any wrongdoing whatsoever, you end up with statistics like 99.9% of plate data that is stored being associated with people who are not suspected of any wrongdoing. I don't think it is appropriate to engage in the mass collection of information about American citizens where you're primarily focused on innocent people based on the possibility that one of those people will have engaged in wrongdoing. Again, checking the place is fine. And I think when you are considering legislation on this going forward, it is important to think not just about the state of technology today, but where technology is headed. Technology is evolving extremely rapidly. Today, it may be the case that there are, perhaps a dozen license plate readers in a city. Well, I don't know what the exact statistics are here, but one can easily imagine license plate reader technology is being incorporated into every stoplight, so that you end up with an extremely granular picture of exactly who passes through what intersection at what time. And so I think that that technological feature needs to be taken into account. Finally, I will just close with a couple of words about drones. Surveillance drones are coming to America. I know it sounds very futuristic. Americans are used to associating drone technology with far-off places such as Yemen and Afghanistan, but drones are coming to America. The Federal Aviation Administration used to ban the use of unmanned aerial vehicles in the United States, except for very limited circumstances. They didn't do that out of privacy concern. They did it because they were concerned about safety. They were concerned, for instance, about the possibility of a drone falling out of the sky and landing on someone on the ground or causing property damage or crashing into another airplane. But Congress recently mandated that the FAA move to integrate drones into the domestic airspace. Drones are potentially a very powerful surveillance tool for location. There are technologies available today where you could fly a high-altitude drone over a medium-sized city and therefore be able to track the movements of individual cars and perhaps even people. But putting that aside, drones today can be equipped with all sorts of powerful cameras that have little in common with the cameras that are attached to our smartphones and our personal cameras. Cameras that have thermal imaging technologies that can potentially even see through opaque surfaces. And so they pose location tracking issues, but also issues for other forms of surveillance. And I'm flagging this issue for you as one to consider as this body considers future privacy legislation. With that, the ACLU has a variety of legislative proposals to address all of these technologies. We would be delighted, honored, and so pleased to work with you on any of these issues. Ranging from GPS and cell phone tracking, trying to ensure that there be a probable cause warrant requirement in place for that type of technology. And I want to add, because I meant to mention this earlier, and I think it's an important point, the ACLU believes that there can be reasonable exceptions to the warrant requirement. So for example, if there's an abducted child situation going on, no one would ever suggest that law enforcement agents need to wait to get a warrant before being able to use powerful tracking technologies in that case. But in routine criminal investigations, we think the warrant and probable cause requirement is the one that best safeguards Americans' privacy, and that there are ways to draft legislation that both allows for reasonable exceptions and make sure that there's a probable cause warrant requirement in the main point. So with that, I'll just thank you very much for the opportunity to speak with you today.
Thank you very much for your testimony, Ms. Crump. Are there questions from members of the committee? We have a couple of minutes that Ms. Crump left on the balance of the time for testimony for questions. Any questions from members? Representative Scott.
Thank you, Mr. Chair. And I don't know if you can answer this, but what is the definition of a drone?
Ms. Crump.
Mr. Chairman, Ms. Scott, The definition of a drone, the more technical, I use the word drone because that is the most common term in common parlance, but the more technical explanation is an unmanned aerial vehicle, and it refers to an aircraft which can fly on its own without any humans on board, but that is controlled by persons either on the ground or through computer software that tracks its movements that way. There's a definition in federal law which can also be used, but which tries to distinguish it, for example, from a model airplane, which no one is really intending to regulate.
Richard Scott.
Thank you, Mr. Chair. Just a follow-up question to that then. So do drones have cameras and microphones, one or the other, or is that defined specifically?
Ms. Crump.
Thank you for the question. That is not defined specifically. All drones have at least some form of cameras, and many of them can carry other forms of technologies. So, for example, there are drones on the market today that have non-lethal forms of force attached to them too, such as things that can shoot beanbags at people.
Other questions for Ms. Crump? Richard Holder.
Thank you, Mr. Chair. It's very obvious to me that Minnesota is way behind the curve in implementing policies around these issues. Are there any particular states in your, with using your expertise, that you think have passed model legislation or are maybe farther along than Minnesota that we might want to take a peek at?
Ms. Crump.
Mr. Chair and Representative Holbert, you know, it's interesting. Different states are ahead on different ones of these issues. Arkansas passed an automatic license plate reader bill, which was pretty good. States in New England have passed legislation on location tracking, and we would be happy after the hearing to get you examples of any legislation that may interest you.
Any other questions for Ms. Crump? Representative Lehman.
Thank you, Mr. Chair. Thanks for being here today. This is really interesting and really very timely, important step. My question is whether there's concern about the use of these kinds of technologies by private parties, or is it only law enforcement that we should be concerned about?
Ms. Crump.
Mr. Chair and Ms. Ludwig, I think that there is concern on both fronts. Private companies, for example, are putting together vast databases of people's location tracking, people's ALPR data, with no oversight whatsoever. The largest company has reported a database with 800 million individual plate hits. I think the use of surveillance drones by private individuals also poses privacy risks. No one wants someone else flying a small surveillance drone over their backyard swimming pool. I think the issues can be more complicated because, for example, individuals have a First Amendment right to take photographs in public, and so there are going to be certain challenges with regulating the First Amendment, regulating drones in particular, since they're equipped with cameras. But I think there's certainly serious privacy implications for private use as well.
Any good questions for Ms. Crump? Representative Hall.
Thank you, Mr. Chair. Is there any, when in my backyard, do I own that airspace up to a certain level, or is that open airspace for anyone? Can I protect that airspace? Do I have to give notice that I'm going to protect my airspace? How does that fall into this realm?
Ms. Crump.
Mr. Chair and Representative, thank you for the question. That is a fascinating and unresolved question. Traditionally, the Supreme Court has made clear that the airspace is a sort of public throughway to the extent it's necessary for planes to fly, but no one has ever been flying planes below 400 feet previously. I think there's a strong argument that to the extent the airspace above your backyard and home is necessary to the enjoyment of that space, that you have a privacy interest in it, but because this technology is unprecedented, no one has ever had to definitively resolve this question before.
Any other questions? Representative Whitberg.
Thank you, Mr. Chair. Ms. Crump, I just wanted to be sure I understood your recommendation, your testimony. Was it your statement, and you touched on this very briefly, that it will take a long time for the court system to resolve the limits on this technology. And the reason why we might urge state action is to set up a set of rules and guidelines to take place in the interim, essentially, while we wait for the court system to work this out. And in a technology that moves and changes quickly, having state-based regulatory structure is what we need to make sure that we're not just, kind of letting the Wild West take place until such time as the courts form doctrines that can be used. Is that basically your point?
Mr. Chair, Representative Winkler, yes, that's exactly right. And you don't have to take it from me. You can take it, as I mentioned, from Justice Alito, who wrote, "In circumstances involving dramatic technological change, the best solution to privacy concerns may be legislative." I don't think that we should sit by and allow individuals' privacy rights to be eroded, waiting for the court system to sort it out, particularly given that very court system's pleas that legislative bodies address this matter in the first instance. And of course, legislative bodies are always free to set privacy guidelines that are higher than the constitutional minimum insisted on by the Fourth Amendment.
Mr. Scott?
Thank you, Mr. Chair. I understand that the tower dumps, they gather data on anybody that's in a geographic area. So do you find then that the cell phone tracker is a better device if you're going to have to use one?
Ms. Crump?
Mr. Chair, Representative, thank you for the question. I think the law enforcement witnesses will in some sense be able to speak better to this, but I think it depends what the purpose is. So for instance, if there is a string of bank robberies and you don't know who's doing it, you may want to do a tower dump so you can figure out what cell phone was present in the geographical location of that bank at a particular time. So there just may be circumstances where that technique is useful in a way that the GPS tracking technology would not be. But again, as long as the standard is adequately high, probable cause, we don't have a problem with that. With the tower dumps in particular, it would be especially useful if individuals whose one of the issues is that innocent people whose data is captured through these techniques never learn about it, because unless you are prosecuted as a result, it is unlikely that anyone will ever tell you that you have been, that law enforcement has obtained your data. And so one of the things that we would like to see are reporting requirements, that if your personal data is being swept up in one of these tower dumps, that law enforcement agents have an obligation to notify you after the fact.
Thank you.
Senator Berger?
Thank you, Mr. Chair. Ms. Crump, listening to this, I'm trying to get the definition for drones. There's an entire industry that exists right now for radio control planes. They've been around for years. Are there implications for this hobby? How does this fit into the equation? You can mount cameras on small RC planes and small RC helicopters that are, you can put anything on these. So are there implications for this industry, and what are your thoughts on that?
Mr. Chair and Representative, so the federal law has successfully distinguished between model aircraft and drones for a long time. I think the distinctions in some ways are artificial, but one just needs to draw a line. So for instance, one could set up rules for flying craft that stay within the line of sight of their operator, as those models traditionally have, and those that range further afield. So I think these lines can be drawn, and we can certainly get back to you with a more specific definition that we think does that in an appropriate way.
Thank you, Ms. Crump. Thank you very much for your testimony. I trust that you will stand by throughout the rest of the hearing in case there's any testimony needed after subsequent testifiers. Thank you. Members will now move on to representatives of law enforcement, including representatives of our own Department of Public Safety. And I want to thank folks for being here, who we invited, including the next testifiers, Commissioner of Public Safety, Dohman, Assistant Commissioner Mark Dunaski, and ECA Assistant Superintendent Drew Evans. Members, we made these invitations to the representatives of law enforcement on the board behind me. In the wake of last session's inaction, on license plate readers legislation. There were outstanding questions regarding, and I'm sorry, I just saw Senator Dibble here too. Senator, I wanted to, he is a representative of the Senate and will be considering this issue in the Senate, so I just wanted to notify members that he is here. Thank you for joining us, Senator Dibble. In the wake of that inaction, there were outstanding concerns regarding the Safe at Home program, an important legislative initiative that has allowed victims of domestic violence to ensure that their data could not be snooped on by their abusers. This was not remedied in the wake of last session, and it is an outstanding issue. There are women who are victims of domestic violence who are currently at risk because of the legislature's inability to address this ongoing and rapidly changing issue. Later on, if we have time, we'll hear from Beth Frazier from the Secretary of State's office, who can speak to this issue. I would note that letters were sent out on 2 occasions in the summer to ask representatives of law enforcement how they plan to address this gap in safety for victims of domestic violence. And you can see on the board, I've only included on this board responses from those agencies who also were invited to testify at this hearing. You also see of the invitees who was sent the letter, who responded to that letter, and you will see based on the testimony who is here today responding to the legislature's questions about this, and we will mark them down if they show up and they testify. The first ones to respond to us, to this inquiry, for the letter of the invitation to testify here today, was our representatives of the Department of Public Safety. I want to thank you for coming, and also for your response to the letter that was initiated by Senator Dibble asking about the cell phone exploitation device that came up in the press, I guess, a couple of months ago. So with that, thank you for being here. Commissioner Dohman, and please introduce yourself for the record.
Thank you, Mr. Chair and members. For the record, my name is Ramona, Commissioner of Public Safety. And with me to my left is Assistant Superintendent Andrew Evans, and to my right is Assistant Commissioner Mark Innes. So I would just like to start off by saying I don't have prepared comments, but I really appreciate the invitation to be here. I appreciate the request, the questions that were sent to us, and the opportunity to respond in the letter that is dated January 6th that you all have. And we are here and prepared to answer any questions that you have. As you know, and as you will hear, I think, throughout the morning, the tools that we use in law enforcement are critical to the missions of the work in protecting people and keeping and saving lives across the state. At the same time, we must balance that with protecting the rights and the privacy of all Minnesotans. And as I stated in my letter, I am committed to doing just that as we work throughout the Department of Public Safety in the missions of the work that we do every day. And so I would open up to any questions at this time.
Thank you, Commissioner Dohman. Are there questions from members? Representative Bostrom.
Thank you, Mr. Chair. So do you have the ability to currently regulate the use, both, I know at the state, which you oversee, but other local units of government, and are you doing that?
Commissioner Dohman.
Mr. Chair, Representative Bostrom, members, we do not have the jurisdiction over local units of government, so sheriff's offices and police departments, but I can tell you that we work in conjunction with them to help establish policy, have those discussions about the way we all operate the equipment that we have.
Commissioner Dohman, in your letter dated January 6th in response to the letter initiated by Senator Dibble, you answered the questions that were outlined. I think one of the questions that was not outlined in that letter was how long has the Department of Public Safety used Kingfish and Stingray?
Mr. Chair and members, I'm going to turn that over to Assistant Superintendent Drew Evans, who is with the VCA, and answer that probably more.
Thank you, Commissioner Dohman. Mr. Evans, please introduce yourself for the record.
I am Drew Evans. I'm the Assistant Superintendent at the Bureau of Criminal Apprehension. And Mr. Chair and members, we've owned this technology since approximately 2005, and it's been utilized since that time.
Thank you. Mr. Evans, are you aware of any other law enforcement agencies in the state of Minnesota who utilize either Kingfish or Stingray?
The Hennepin County Sheriff's Office and the Bureau of Criminal Apprehension is part of the Department of Public Safety are the two entities that utilize this equipment.
Thank you. Any other questions for the testifiers? Representative Newberger.
Commissioner, thank you for coming today. Thank you, Mr. Chair. Just a quick thought. If we go ahead and enact some type of restrictions on a state level for these agencies to restrict the use of these technologies, is there a difference? So we tell the state agencies, no, you can't do this. But is the federal government, what's the restrictions on them? So if your department can't use this technology, what's to stop the federal government from doing the same thing? Bring me up to speed on that.
Mr. Chair and representatives, the federal government has its own levels of oversight through their own committees, through their own legislative process. They have many restrictions that are in place through the U.S. Code relating to these very same technologies. Many of our statutes that we do have currently under 626A, which regulates a lot of our use of pen registers, mobile tracking devices, wiretaps, Title III intercepts. There's statutes at the federal level that are similar or mirror our statutes at the state level. So there are many restrictions that continue to be in place for the federal government, especially when you're talking about domestic-related criminal investigations by entities such as the FBI and the Department of Homeland Security.
Thank you, Representative.
So just to be straight, so even if we moved ahead and we locked all of this down and we completely restricted the state departments, the departments from Minnesota from using these technologies, we really have no say in the federal government with the technology that they would use, correct?
That's correct.
Thank you.
Representative Scott.
Thank you, Mr. Chair, and thank you for being here today. What are the protocols used for using these devices? What steps are taken? Are the court orders, administrative subpoenas? What are the hoops you have to jump through to use it?
Mr. Chair, Representative Scott, it varies depending on what has actually occurred. So the process that the Bureau of Criminal Apprehension utilizes equipment for one of our partners is that primarily we utilize this equipment in violent crime investigations, homicides, attempted homicides, aggravated robberies, crimes that are impacting our communities and violent crime. In order to use this equipment, we primarily use one of two methods. We obtain a court order, which is based on these statutes in 626A, in conjunction with a number of federal statutes that allow for state and local entities to obtain orders based on federal statutes. And that allows us to utilize this equipment in that manner to track the cell phones utilizing this equipment. We may use a subpoena if we're obtaining information at a much lower level, but anytime we're doing any sort of tracking of movements of anybody using this technology, we use a court order, or in situations, as the previous testifier noted, in exigent circumstances where we feel somebody's life is in imminent danger if we don't utilize this technology immediately, and we don't have the time to get a court order that would result in somebody's life potentially being lost or somebody being gravely harmed.
Representative Scott.
Thank you, Mr. Chair. Thank you for that answer. Can you take me through what an administrative subpoena is exactly and what the threshold is for that?
Mr. Evans.
Mr. Chair, Representative Scott, an administrative subpoena is a statutorily created court, or not court approved, it's approved by a county attorney, or there's a provision for the Attorney General's office. Typically, when we're getting an administrative subpoena, we're getting records that are outlined in the statute, such as, for example, it could be information on a subscriber to a cell phone, but we can't get content information. For example, on an administrative subpoena, you would not be able to obtain text message information. You would not be able to, with an administrative subpoena, obtain tower sector location in the state of Minnesota, as was referenced in the previous testifier. What you're getting are essentially call detail records that may indicate dialed numbers in and out on a historical basis. If we're asking for something such as a proactive, or that we're getting real-time information, we need to utilize one of these other orders, such as a pen register order, which would allow for more information to be obtained in real time, dial numbers in and out during that process. process. But again, that's a higher level order when we talk about a pen register order. And just to clarify for members of the committee, we often hear discussions about this as a discussion between search warrants and a different type of order. Much of this is semantics. What we really need to consider is the standard of review by the judicial reviewers. So a pen register is reviewed and approved by a neutral detached magistrate, a district court judge of the state of Minnesota, and there is an affidavit outlining the information that we have presented to that judge to obtain a pen register or a mobile tracking, electronic tracking device order. So a subpoena is when we're asking for information at a much lower threshold where there's less privacy interests implicated.
Mr. Evans, in evidence that yielded the administrative subpoena, is that used as supporting evidence to gain a warrant in subsequent circumstances?
Mr. Chair, in certain circumstances, it may be. It really depends on the facts and circumstances. So in a situation such as a drug investigation, you may use an administrative subpoena to gain information on a person that may be subscribing to a particular phone number in a particular residence, and it may put you to that information, but rarely is an administrative subpoena used in and of itself as a basis for a warrant. It's used perhaps as one piece of many different pieces of information that we outline in the search warrant to obtain a warrant.
First up,
Thank you, Mr. Chair, and I greatly appreciate you taking the time to appear here today. In your answer to how long cellular data is kept, I noticed that you say it's kept on the device until it's used again and then overridden. Does that mean it's not downloaded and kept for historical data at any time? It's only kept on the machine and it's not capable of being downloaded?
Mr. Evans.
Mr. Chair, Representative Harteau, with the, to be clear, with the cellular exploitation device, it is not kept. We do not download the data. It is utilized in a fashion, as we've noted in the Commissioner's letter, that it is used this to locate or reduce the area of location probability for a particular phone, so there is no necessity to maintain that data. There are times when we do maintain cellular record data, but it is unconnected to this particular equipment.
Thank you, Mr. Chair. And I understand you don't keep it, but is it capable of being downloaded? I mean, is this something that could be done that we need to possibly look at for future reference? I mean, if it's capable of being kept, I think that it's just because you have a policy that doesn't use it in that way, that doesn't mean that other agencies may not decide to download it and keep that data. Is that fair?
Mr. Evans.
Mr. Chair, Representative, the data will likely be able to be maintained in some fashion. However, the usefulness of that information will be limited.
Representative Russo.
Thank you, Mr. Chair. Since I had to look it up for the benefit of the other people, could you tell us what a pen register is briefly?
Go ahead,
Mr. Chair, Representative, a pen register is a order that allows law enforcement to see the incoming and outgoing phone calls, no content, just dial digits in and out of a particular target telephone. So if a person is a target of a criminal investigation, we may be monitoring the incoming and outgoing phone calls, often in, say, a drug conspiracy investigation.
Representative Winter.
Thank you, Mr. Chair. Commissioner, thank you very much for coming today and for sharing information with us. It's very obviously difficult for us to make policy decisions without adequate information, and I thought your answers were direct and straightforward in response to this letter from Senator Dibble. So I think that's very important. Ms. Crump from the ACLU talked about the Fourth Amendment and how states may need to take legislative action to regulate citizen privacy because of evolving technology. And based on the testimony I'm hearing from Mr. Evans, it sounds like this information is used in investigation and law enforcement work generally according to the basic outlines of the Fourth Amendment. But what about the broader privacy interest? Does your department feel that it has enough guidelines from the state statutes about how information should be used, how it should be kept, what level of disclosure of the use of that information is appropriate to the public? Is this, I trust you, but do we have anything more than that in statute? And maybe should we consider more, given that this technology is available to more than just your agency? Commissioner Dohman.
Mr. Chair, Representative Winkler, and members, I can tell you that there isn't a day that goes by that we don't, at the Commissioner's office, have discussions about data privacy and data privacy issues and rights. And as we make any sort of policy decisions across the agency, we are always and continually evaluating and, as I mentioned earlier, balancing those rights and as compared to the mission of the work that we do. And so for anybody who has ever looked at Chapter 13 data privacy laws, they are very complex, and it is very, very difficult sometimes to understand. And so we spend a lot of time evaluating that. And so we would be happy to work with you to try to figure out if there are better ways to have the laws in place so that we can work within them, most importantly, respecting the privacy rights of individuals.
Mr. Chair, Commissioners, so if you're willing to examine the statutes to make sure that we have clear guidance for you and clear rules to follow, I take from that you're also willing to then be open in your discussions about what you do and how you do it, up to a certain point, I suppose, so that we can be better informed about decision-making in the legislature as well.
Commissioner Dohman. Mr. Chair, Representative Winkler, without a doubt, we would be happy to do that.
Thank you.
Thank you, Mr. Chair. And Commissioner, kind of piggybacking on Representative Winkler's comments, we as policymakers, I'm sure are all in agreement that we're not trying to protect bad actors or throttle law enforcement's ability to keep the public safe. However, we are very concerned about innocent residents in Minnesota. There have been many incidences where it appears that law enforcement has gone far beyond using data for public safety purposes, and been fishing or looking up people just out of curiosity. And so as we move forward trying to implement new policy, we have to look at the track record, if you will. And so I want to spend just a little bit of time going back to the driver's license records, your department's reaction to that. And in particular, we for nearly 10 years, when innocent law-abiding citizens would inquire about the use of their data, they would be provided information on the agency that was looking up, many times the individual, as part of their right to see how their information was being used. Under your administration in recent years, you wrote a letter in which you used a nearly 10-year-old statute was put into place for cookies to shield that information. And Mary Hammer did a story, and the governor said that he thought that the identities of officers in those instances should be available to the individual. Where is your department in that policy at this point?
Commissioner Dohman.
Mr. Chair, Representative Holberg, and members, we currently, I have been advised by legal counsel that the interpretation as we see it is that the specific name of the individual officer who has access to the data is not public information.
And Mr. Chair, again, that was, your administration took a law that was in place for when people were interacting with the state website, cookie information, and used it in that manner. For years prior to that, that law sat on the books and was not used in that way. Subsequent to that, the governor has said that he thinks that those identities should be available to the users. Will your department be coming forward with the law to allow for that disclosure? Will you be backing off your interpretation of using that cookie language? It was never intended, that law was never intended to shield law enforcement that were accessing individuals' information in a non-investigative mode from their identities being shielded from the public.
Commissioner Dohman.
Mr. Chair, Representative Holberg, and members, at the Department of Public Safety, we do not, when we audit the use and access of VBS data, we do not determine misuse of that data. But we do work with law enforcement agencies across the state of Minnesota when we see sort of anomalies or situations where we think that the use is greater than sort of an average, if you will. And the individual law enforcement officer has due process rights within their agency, and then law enforcement agencies, once notified by us, can determine whether or not they want to do an investigation into the use. And then it is that agency that determines the misuse. So we work in collaboration with law enforcement across the state to work to ensure that any misuse does not happen.
And Mr. Chair, I might remind people that that standard of review failed to even flag the massive misuse of information in the DNR that kind of made this whole thing explode. So have you changed your policy since then? I mean, you say that you were flagging your top 50 users. That process did not find somebody who was looking up thousands of records. So some may say that if he didn't even make the top 50 in your standards for checks and balances, are there 50 individuals that are worse than he, or what has changed?
Mr. Chair, Representative Holberg, and members, we have made several changes in the past 2 years regarding the DBS data. And currently, we are just in the process of actually shutting down the law enforcement, the LE support process by which law enforcement officers can access DBS data. And all law enforcement officers across the state, hopefully within the next first quarter of 2014, will be able to, or will the access to the driver's license data will have to go through a web portal at the DCA, where we have stricter auditing controls, we have people monitoring in a different means than we had with the law enforcement support system at driver and vehicle services. In addition to that, we've added training. We work with law enforcement across the state to train officers on the use of the data and the laws surrounding or pertaining to that data. And I can tell you that law enforcement has responded.
I'm sorry, one last question. So 3 to 4 years ago, when somebody would make a request, they'd get the officer's name, the department, and the dates and nature of the inquiries into their data. Then you wrote a letter using the cookie language, and the individuals' names were no longer available, only the agencies, the dates, etc. I have been told that more recent requests for this information have failed to even include the agency's name. Is that correct?
Mr. Dohman. Mr. Chair, Representative Holbert, and members, my understanding is that we do not have record of ever releasing the names of individual officers in the history of the law enforcement LE support system. And so I don't know that that information was released prior to my coming to the state. In addition to that, I'm sorry, the follow-up question was?
I appreciate the line of questioning, and it's important. I want to make sure we have time to get to the other subject matter of hearing, and it seems to me that this would be worth hearing about later on when the legislative session starts as well, so please keep that in mind.
Mr. Chair, this is my last question. I've been told that recent requests for information that individuals are being denied the name of the agency that made the request. Is that correct?
Mr. Dohman.
Mr. Chair, Representative Holbert, and members, my understanding is that we continue to release the same information that we have in the past.
All right, thank you.
Thank you. Members, there being no other questions for Commissioner Dohman as well as the representative of the Department of Public Safety here, I want to again extend my appreciation for you responding to our invitation to the committee hearing. Also noting, based on Mr. Evans' statements, that the subject matter that spurred this oversight hearing, that being cell phone exploitation devices, is only utilized, as far as we know of, by 2 law enforcement agencies in the state of Minnesota, that being the Department of Public Safety via the Bureau of Criminal Apprehension and the Hennepin County Sheriff's Office. I would ask, is Sheriff Rich Stanek here today? Sheriff Rich Stanek. Okay, then we have no other questions, I guess, regarding Kingfisher Stingray. Thank you very much, Commissioner Dohman and representatives. Minneapolis Police Chief Janee Harteau. Thank you for coming, Chief Harteau. Please introduce yourself to us.
Good morning. Thank you for the invitation. My name is Janee Harteau. I'm currently the Minneapolis Police Chief.
Thank you. Did you have any testimony, Chief Harteau, or did you just want to respond to questions from the committee?
I would be happy to testify to the 3 questions and then answer any questions that anybody has.
Great, thank you. Go ahead and proceed.
First, I want to echo the Commissioner's opening remarks about the need and importance of technology for public safety, but also I too want to ensure a balance of the average citizen's privacy. With respect to cell phone tracking, the MPD does not have tracking or monitoring technology. When this information is needed based on an investigation, which is our most serious investigations, most commonly when we are looking for wanted violent fugitives, MPD offers a search warrant that is reviewed and signed by the judge. MPD makes a request to the BCA to use their tracking technology. We do not operate the system and are given the information by the BCA. Second, with respect to license plate readers, the Minneapolis Police Department has 2 stationary LPRs located on the Broadway Bridge. We have 4 vehicle-mounted LPRs, 1 in each of the precincts. We have 5 precincts, so the only one that we currently don't have a mobile LPR in is the 2nd precinct. The city clerk's office contacted the state and notified them that we retain the LPR information for 90 days. This investigative information is retained until the investigation is completed. During the 90 days, the data is non-public. After the 90 days, the data is erased. I would make a comment that a zero data retention will essentially negate this resource as an investigative tool and would be used solely as a patrol tool for active license plate hits. We're not looking for a forever retention. We realize the balance there again, but a 90 would be most helpful. And then last, with drones. The MPD does not own any flying unmanned drone aircraft. At this time, we do not intend to purchase or use this type of equipment.
Thank you for your testimony, Chief Harteau. Are there questions from members of the committee? Representative Scott.
Thank you, Mr. Chair. Chief, how long does the process take then if you want to get a search warrant? And does that ever, because you don't have some of these technologies yourself, has it ever deterred you from catching a bad guy or a bad person in a timely manner?
Chief Harteau.
Mr. Chair, Representative Scott. I don't know the exact time. I guess it would certainly vary. And I wouldn't know to specifics to be able to tell you if it's ever prevented. It is a very useful tool.
Thank you, Mr. Chair. Chief Harteau, in your testimony, you said that you get information from the BCA or the Department of Public Safety. Do you not work with the Hennepin County Sheriff to obtain data through some of the technology that they have available?
Mr. Chair, Representative Winkler, we currently do utilize the BCA. Have we ever used Hennepin County Sheriff's Office? I do not know. But currently, we have a working relationship with the BCA.
Thank you, Mr. Chair. Chief Harteau, I guess the curiosity I would have is what advantage do you see as a department in working with the BCA versus the Hennepin County Sheriff, given that you're entirely within Hennepin County?
Chief Harteau.
Mr. Chair, Representative Winkler, that's just a relationship that's been established between our investigators and the BCA prior to me becoming the police chief.
Thank you. Representative Scott.
Thank you, Mr. Chair. Chief, is there a price difference? Does Hennepin County charge you if you use them versus the BCA doesn't, or does that play into the decision-making at all?
Chief Harteau.
Mr. Chair, Representative Scott, I do not know the cost specific, and as I stated earlier, this is just a relationship that had been set up in the process, an investigative process prior to me becoming the police chief that seems to be working well.
Any questions? Chief Harteau, I have a question. You stated that you'd like to retain license plate data reader information for 90 days for investigative purposes.
Correct.
In the disclosures that occurred in June of 2012 with your department, it was shown that 99.2% of the images were on innocent people. I'm wondering, what do you think, what kinds of crimes do you think I could commit in the next 90 days that give you cause to hold on to my location in your city?
Mr. Chair and members of the committee, I think the question is the unknown. We have used the data to connect data and solve crimes in the past, whether it be in domestic situations, aggravated assault, robbery suspects that we didn't know specific information until the investigation became further, where we could look at some of that license plate information.
I understand that, Chief Harteau, in the abstract, but you're holding on to my data, my location, where I am, who I visit, where I go, what I'm doing, how long I stay there, potentially. And I, for the life of me, can't figure out why you need to hold on to my data. And I'm wondering if you can give me a reason of why you want to hold on to my data. There may be other members of the committee here who drove to Minneapolis in recent days, or in the next 90 days, who you hold their information to, and they may have those questions, but I'm asking why you have to hold on to mine.
Mr. Chair and members, because I don't know what I don't know, and I don't know when I would need that from you specifically.
Thank you. I don't have any further questions. Representative Lee.
Thank you, Mr. Chair, and you know, I have, of course, a lot of the same concerns as Representative Lash. So, given what you just said, why pick 90 days? You know, why not pick 30 days or a year? If you don't know what you don't know, you'll never know what you don't know. You might as well keep it for the whole lifetime under that sort of explanation of what the need is. So, I mean, why do you pick 90 days?
Chief Harteau.
Mr. Chair, Representative Lee. That just seems to be when we look in the past cases that we've investigated and how much time we need to go back, it seemed to be one that was most recommended. It certainly can be further conversation, but a zero retention makes it very challenging for us to go back to any of the data. It's information that is only looked at by ours and accessed by our Strategic Information Center and our crime analysis.
Any questions from members of the committee? Thank you very much for your testimony and for coming today, Chief. St. Paul Police Chief Tom Smith.
Chief Smith, as the police chief and assistant chief ISO is here as well. Thank you for being here. I want to thank you for being here. I know it's awkward, as I said at the beginning of the hearing. But we appreciate you being here and being willing to answer questions. Chief, did you want to answer questions, or did you want to address the committee first, or did you just want to proceed right to questions?
If I could just clarify just a couple of things I think would be helpful for the committee.
Go ahead, Chief.
Thank you, committee, for allowing us to be here today. I want to start off by also thanking the ACLU. I think it's important to be transparent. These are issues that I am very aware of, along with my colleagues that you've heard before me today. And I want to give the committee just a little bit of history. I, along with others in this room, I am a member of the International Association of Chiefs of Police. It's the largest professional police organization in North America. Also, I am a member, as other colleagues are in here, including Chief Harteau, a member of the Police Executive Research Forum. And the issues that we're talking about today are issues that on a national basis we are also discussing as law enforcement leaders for our country. I think it's really important to frame that so that you understand that, like, for instance, the International Association of Chiefs of Police has model suggestions for everything that we're discussing here today. And they do that from extensive research in collaboration with different people, best practices and things that just don't work. Things that concern every one of you concern me as well, because when I take the uniform off, although I'm a cop 24 hours a day, I understand very well privacy issues for our citizens, especially here in the state of Minnesota. Give you another framework, just outside of law enforcement. a lot of us have devices, and now I have grandchildren because I'm older, that if you have a cell phone with your child or grandchildren, you can actually find out exactly where that child is, right now, from right inside this chambers. For those of you that drive a newer car and have OnStar, OnStar knows where you are 24/7. There's some great advantages to having that in case we're involved with an accident. I know I go to northern Minnesota frequently. I'm on an off-road and something would happen. It's great to have OnStar. I really wanted it for my wife. But I mean, if you punch in directions, they know where you are through GPS national tracking every single day. So I just wanted people to understand that there are other things out there, including the new ISO 7. On many of you that have iPhones or iPads or whatever type of devices, I continue to learn. I come from a time when you had to use a quarter to use a telephone to call back to our communication center. That's how old I am. But I also understand and want to frame that if we talk about license plate recognition readers. When I was a young police officer, we did the same things today without technology. I would get a hot sheet at roll call that would tell me about all the bad guys in my defined area and where they might be, including their addresses and probably a mugshot on that piece of paper. We also, and officers still do that today, had a hot sheet on stolen vehicles within the city of St. Paul. And many times we'd get Minneapolis information as well because a lot of our stolen vehicles would go between our two cities. Officers would take that on, right onto their dashboard in the car. Then we'd use binoculars, and that's why I have to wear glasses now and squint, because we look at license plates to try to match up the bad person, the suspect, or those stolen vehicles with that information. Today we have license plate recognition readers. We have 10 of them in St. Paul. We don't have any in fixed locations. And we use those devices not only to solve crimes, but to find stolen vehicles. For those of you, I'm sure that you've kind of studied up on this, you know, those readers, depending on the weather and all sorts of different environmental factors, can grab 1,000 to 1,800 license plate images within a minute in a perfect type of setting. And that information is then used and has been used by us. I will tell you that in 2012, it helped us solve 2 homicide cases and for us to find suspects. When you talk about other technology, because I want to be transparent today, we've got more than that. We've got Project Lifesaver. We've got subscribers that subscribe to the St. Paul Police Department with, for a better lack of the term, a watch or device that they wear because their families believe or they are vulnerable or they feel as though that they may wander away, they may have Alzheimer's. There's all sorts of different reasons for that. We've trained our officers in that technology, and we've been able to find, when an alert goes out, those individuals. In fact, we had a case last year during the winter, downtown St. Paul, where we used that technology to find a lost person. So there's a lot of stuff out there, and I understand that. We don't use, we work very closely with the BCA, as does, you heard from Chief Harteau, with the technology as far as triggerfish or kingfish. We don't have those devices. I will tell you that every time that we use that information and we work closely with our BCA partners, we obtain a search warrant first, signed by a judge, and then we work with and contact the BCA to use that technology to find a specific individual that's been involved with a specific crime. GPS. Federal law changed over a year ago. Anytime that we use GPS technology to track or put, for a better lack of the term, a tracker on somebody's vehicle, we have to get a warrant signed by a judge before we do that. To do that, we have to have probable cause. And we use this tool in a limited manner because I do believe, and I agree with this committee, that it should not be widespread and not have policies and procedures where you may have an opportunity for misuse. So we don't deal with drone technology. I will tell you as a chief, I travel on a national basis. I know some departments that are starting to use that technology. That's not something that we've used here. I couldn't even testify on it because I haven't really researched that technology whatsoever. Could it have a good implication for law enforcement? I'm an old SWAT guy. I ran our SWAT team for a long time. If I could keep you safe and I had someone barricaded in a situation and I could use that technology to see that person or know that they're there without putting officers in harm's way by having to put them right there, would I use that and support that? Absolutely I would, and I think this committee would as well. But again, that's something down the road. I want to stick with what we have here today. I'm glad to answer any questions. I will tell you that I take this very seriously. We have very strict policies and procedures within the St. Paul Police Department. We work with our partners locally here. I don't know that we've ever done a cell phone tower dump. I don't believe we've ever done that. It hasn't happened since I've been the chief for 4 years or an assistant chief. I can't explain any more of that. But what I would say is that if I was a rural sheriff, that might be something that's important to me. A cell phone dump here in the Twin City area would give you just numbers. And you have to have analysts and to figure out what number within that needle in the haystack might have to do with your specific investigation. If I'm a rural sheriff, I don't want to speak again. You can't just say one size fits all. That may be very important to me, where that cell phone dump would be very specific and much less as far as numbers, the amount of numbers that you would get to help me with the specific or solve a specific crime. So with that, I'm willing to take questions. And again, I want to thank you because I think it is important. It might be uncomfortable for some of us, Mr. Chairman, but I think it's important for all of us to be transparent. It's the only way for us to move forward and figure out what's best for our state.
Thank you for your testimony, Chief Smith. I want to apologize to Ken Reed. I called him Todd Axel when I came up here. Both your business cards are both right up on my bulletin board, and so I realized my mistake right away. So are there questions from members of the committee for either Assistant Chief Reed or Chief Smith? Representative Hillstrom.
Thank you. You spoke of model legislation. Is that like on a website somewhere, or do you have copies of it that we could take a look at?
Chief Mr. Chair and Representative, the IACP, International Association of Chiefs of Police, has a website. You can just put in IACP, Google it, it'll come up with their website. They do have information, again, about model policies that they put out and suggestions. They're suggestions for departments throughout the country. I can tell you that we look at that. I'm also a member of IACP, so as far as committees that I may be part of, we talk about different things along these lines and what might be best practice. So we look at that and use that for research. As you heard Commissioner Dohman say, each department is kind of separate here in the state of Minnesota. Police departments, a sheriff's office, on what your policies might be. But I like to use that because that is a well-defined with very expert individuals to give us suggestions on how to model our policies.
Any other questions for Chief Smith? Representative Johnson.
Mr. Chair, Chief Smith, just got a little question on the license plate reader issue. Being law enforcement background myself, I understand how important this information can be and how helpful it can be to an investigation. But I'm just wondering what type of policies that you have in place at this time and that you think might be good for us to also look at for keeping what we used to call investigation fishing experiments. Just looking at the data to see what's out there. Do you have any policies in place to make sure these fishing expeditions or keep track of who's actually looking at this information? Chief Smith.
Mr. Chair and Representative, and I only can speak for the St. Paul Police Department, so I just want to be clear on that. We do have a policy that we can make copies. We actually have a copy of it here for our officers and our department. One thing I want to clarify for the committee is that one of the things with license plate recognition readers, and I think it's kind of a misnomer, is that it captures, and again, we don't have any fixed ones, but we do have 10 on vehicles. It captures only the picture of the license plate. I think that we do have citizens that actually believe that it also comes with the picture. Now, if you had investigative reason to look at that specific, out of all those numbers that you get, or you get a hit, it's a stolen vehicle, or that plate was linked to a specific crime, then of course you want to continue your investigation, as you said, Mr. Chief or Representative, and take a look, and you probably go and you look and see what that person looked like, or who possibly was driving the car. Because I don't know about all the members on the committee here, but I don't always drive my personal vehicle. I have other family members that drive it as well. So I capture one time, one plate in one place, but I don't know who's even driving that vehicle at that time. So but we do have specifics here, as with Minneapolis. I will be very transparent here. Right now, we are holding that information for 90 days. Mr. Chair, I know you questioned Chief Harteau. I wanted to actually expand on her answer to let you know that the Minnesota Chiefs of Police Association, we have discussed this information. I'm sure the Sheriff's Association, I see Mr. Franklin here, has as well. I can speak for the Minnesota Chiefs. to say that we've looked at 90 days, again, as far as investigative reasons, as far as that was the number of days that we came up with in that group, many of the chiefs. At first it was 180 days, but I think that we settled on 90. I've been a part of a smaller group with the East Metro Chiefs of Police in Ramsey County where we've talked about 90 days. But I've heard many different things on that topic, and I understand the questions, and I think that there should be strict guidelines in place.
Chief Smith, so and I appreciate that answer. And you know me a little bit better than Chief Harteau. So you maybe have a little bit better idea of what I could do wrong in the next 90 days. I want to know, what do you think I'm going to do?
Mr. Chair, I think that you have an impeccable background and you wouldn't do anything wrong. And, but on a serious note, again, I just want to end by saying I welcome speaking when we speak with the ACLU locally here. When we came out with our license plate recognition reader program in 2008, we actually tried to be transparent, let the media know what we were doing and other things. As we go forward, can we do things better? I'm always open to look at that. We have professional organizations also such as the ICP that I think can help this committee. If you look on their website, it will tell you about different challenges in different states on these same exact issues, but also some best practices. And those are some of the things that I think it's very important for us as law enforcement professionals who serve all of you to be able to come and give you the latest of what we've learned through our own analysis so that we are always trying to do the right thing by our citizens.
Thank you, Chief Smith. Other questions from Representative Howe?
Thank you, Mr. Chair, and thanks for coming here, Chief. And I guess my question comes to is, if you get a hit on one of those license plate readers and it pops up, do you have the ability to go back and look at maybe a traffic camera or try to put a face to the plate, to the car? Is that a possibility that's out there? I'm not too familiar with where cameras are these days. I know they got them on the interstate. I assume that some cities have them out for traffic cameras. Is that a possibility? Is that ability available to you?
Mr. Chair, Representative, what I will say is that in different states and cities, yes, it is. Absolutely, that technology is available. I'll also be transparent and say that we have 200 closed caption television cameras located along University Avenue in the downtown, light rail, all things that within a specific date and time, could we technically, you capture license plate 123 ABC, it's at Rice and University, could we try to look at a camera and see if we captured an image of someone? I will tell you that that technology is not connected together. I will tell you that people are looking at trying to connect those dots. We don't have that capability. Could that happen? Yes. Does it happen in other cities, especially in fixed locations? Yes, I can tell you that I have heard that happening.
Representative Howe? Members, I would note also, the last question after Representative Howe is going to be Representative Hilbert's with respect to Chief Smith. We also have, after this, Sheriff Dave Mueller from Rochester, who was good enough to drive all the way up here. We have Don Gemberling and Rich Neumeister, and we want to have time for public testimony, which we want to include Professor McKean Levy Pounds, who is here, I believe, also Kurt Hanna and Beth Frazier. So we're going to have to tighten down the questions. Go ahead,
Thank you, Mr. Chair. The only follow-up question I have is, do you know, and I don't know if you have this information or not, do you know how long that photographic data from those cameras are kept?
I can't speak for any other departments, sir. I know that for us, it can be kept up to 30 days, and then that is purged and overridden.
Thank you, Mr. Chairman. I think I just want to make a comment. Chief, you went through a variety of technologies, cell phones, iPads, etc. I think there's a distinct difference. Apple and OnStar can't take away people's freedoms or liberties, and when you use those products, you do it by choice, etc. These license plate readers and other surveillance technologies are done far beyond individuals' knowledge. We've seen abuses, and I think the license plate reader is certainly one technology, and it's just, as you said, just a license plate. but it is the precursor to facial recognition. And the same technology will soon be able to scan crowds, etc., and store facial images. And it's a real type of tracking and an opportunity for great abuse. And again, nobody wants to protect the bad actors, but we have to make sure that these policies protect innocent citizens' rights to privacy as well.
And
clarification.
thank you, Representative Holbrook, and thank you, Chief Smith. Thank you, Assistant Chief. Also, County Sheriff Dave Mueller. Sheriff Mueller, please introduce yourself to the record. And we also have Jim Franklin, representing the Minnesota Sheriff's Association.
Good morning. Thank you for allowing me to testify as well. My name is Dave Mueller. I'm Olmstead County Sheriff. Now, just say a couple brief comments. I appreciate the work of the ACLU and the importance that they also share about our ability to have this technology to allow us to do our job well. I'm going to speak only to a couple of items. We also do not have drones. And we do not have kingfish or triggerfish or other technology that we would, if we did, utilize that information through the DCA or through Hennepin County. With me today is our Executive Director for the Sheriff's Office, or Minnesota State Sheriff's Association, and I'll have Jim speak to introduce himself as well.
Thank you for that and for being here, Sheriff Mueller. And I will also ask, to the extent this is an oversight hearing, Mr. Franklin, if you can speak to specifically if there are policies that are endorsed by the Minnesota Sheriff's Association and that are used as a matter of policy. That's, I think, what the committee is interested in hearing with respect to government surveillance.
Mr. Chairman, members, I think Chief Smith has done a very good job of outlining the work that the IACP, International Chiefs of Police Association, and National Sheriff's Association work collaboratively together on varying types of policies. Yes, we do support those. Yes, we do work together. Yes, we do collaborate. Could we do better? Could we do more? I think that's a fair question, and I think we certainly can and are focused to do that. One of the reasons to be here today is to just indicate that our Sheriff's Association, along with our Chiefs Association, want to move forward on standardized policies. We have agreed on the 90 days. Many of our agencies are using that. Some are using 60. We look forward to coming up with something. The solution to this is the longer we hold the data, the greater the likelihood or the probability is that you're going to find something to solve a criminal action. As soon as that data is gone, it is gone. The likelihood of solving something dissipates. So that is one of the reasons why we think the holding of that data is important.
Thank you, Mr. Franklin. Are there questions from members of the committee? And I'm sorry, I may have missed it, Sheriff Mueller, but did you say you do have license plate readers that you use in Olmstead County, or no?
Mr. Chair and members, yes, we do. We have 4 mobile license plate readers. And just to clarify one point that was shared before, the license plate readers technically have the ability to read that license plate, but as an example, I have a photograph. There are times when that license plate will also provide a little bit more of the detail of actually that vehicle. So it's not only the license plate, it can actually pick up portions or all of the vehicle, and at times it has, by utilization, you'll find on the internet that it has identified a person that came out of the vehicle as well. So there is capability and capacity for that license plate reader to grab more than just a license plate. There are 4 different camera systems on the mobile vehicle, 2 that are on the front, 1 that's facing to the rear, and 1 that's on the side that would perhaps go to a parking lot and be able to receive vehicle license plates from a 90-degree angle. So just to give you a little bit of information, you asked the question, Mr. Chair, about what possible things could happen and why these are incredibly important for us and why 90 days is an important element for us as well. I'll try to share with you that if there is an armed robbery in the city of Rochester police do not have this available technology, but I would ask, and we have put in our rules for our deputies, policies for our deputies to go in and try to then survey, if you will, the area where an armed robbery occurred or a homicide occurred to try to capture license plate images that we could later be able to look at and potentially identify potential suspects. So these are important things, and these don't happen because we can do that in a matter of minutes. Sometimes that information will take days, weeks for us to actually get through and be able to look at. So that's an example of where we would utilize that technology. And again, I appreciate the privacy issues that we have, but there's also information that we can obtain, and we want to make sure that we're solving those most important crimes as well, keeping our communities safe.
Thank you for your testimony. Representative Wicker. Thank you, Mr. Chair. This question is either for Mr. Franklin or for Sheriff Mueller. By your presence here, Chief Harteau, Chief Smith, the Commissioner of Public Safety, all of whom came to offer testimony and answer questions about technology and about the capabilities, policies, procedures that are wrapped around that technology. What limits do you see on the level of transparency that Chief Smith referenced? What limits on transparency do you see that your agencies should have with respect to the public's right to know and the legislature's ability to conduct oversight? Sure, if you will.
If I can pass that on to the Executive Director, I'll let him speak to a bit of that.
Actually, Sheriff Mueller, no disrespect, Mr. Franklin, but not being a policymaker, you're not in a position, I think, to answer, unless Representative Wimpy, you wanted to phrase it in a way that the association can do it. And the intention of this committee is to ask questions of policymakers. If Mr. Franklin is in a position to make policy for the use of law enforcement in Minnesota, I'm more than interested in hearing about that. But as I understand it, he's a representative of the association. So, Representative Wimpy.
Well, I think Mr. Chair, Mr. Franklin can probably address it. I guess the question is, what restrictions on the public's right to know the policies, procedures, and capabilities of law enforcement agencies do you think are reasonable, or are there any?
Mr. Franklin, has the association taken a position with respect to Representative Winkler's question?
We've not taken a, Mr. Chairman, we've not taken a specific policy on that particular question. That particular question comes up as we look at the access of data and the balancing right of the individual to know. I think we have a number of constitutional issues, we have a number of issues of Supreme Court decisions that also are impacted here. We, as law enforcement, are only as good as the people we serve allow us to be. We rely heavily on communication, information from the public to solve our crimes. If that is not forthcoming, and that exchange is not there, and that trust is not there, it impedes our ability to do our job. So I think to Representative's question, it is critical that we are open, honest, and have that dialogue. There may be investigative data under 13.82 while an investigation is going on that cannot be revealed for a number of different reasons. But as we all know, once a court case is done, it is open and public data. Additionally, we have the entire issue of suppression of evidence that is brought forward, both by a prosecutor that says it's not good enough or by a court that suppresses it for some reason. So I think, to your question, sir, it is very important that we are transparent, that we find the policies that keep the right and appropriate balances between our law enforcement concerns and our citizen concerns, because we are representative of the people.
Thank you for the answer, Mr. Franklin. Thank you for your testimony as well, Sheriff Mueller and Mr. Franklin, for being here.
Thank you.
Next testifier, Gemberling, Minnesota Coalition on Government Information. And apologize, Mr. Gemberling, but if you can keep your testimony limited to 5 minutes.
I'll do the best I can, Mr. Chairman.
I'm actually not here from the Minnesota Coalition on Government Information. I'm here because I've been working with this stuff for 43 years. This is my 40th legislative session in which I've watched you struggle with these issues, okay? The handouts in the packet, which I won't go through in detail, that start with a really wonderful cartoon of George Orwell, are for me, okay? I majored in history at college, and that's my orientation for much of how we view these things and how you work with them. So in your packet, you will find the cartoon of Orwell. You will find a list of things that have occurred in the past, a variety of things that play on the issue of government surveillance, particularly by law enforcement. So how did George Orwell and those things fit together? It's important to know that George Orwell, who some of us think was an extraordinarily genius type person, who could look into the future in 1949 and see the society that we're living in now. And part of Orwell's genius comes from two places. Number one, his early career before he became a writer was he was a cop. Okay? Most people don't know that. The other thing was that Orwell did was he fought in the Spanish Civil War, and he saw the conflict between the communists in Spain and the Nazis in Spain, who are all stand-ins for the communists in the Soviet Union and the Nazis in Germany and in Italy. And so he came to understand the power of law enforcement, and he came to understand the power that it can give the totalitarian kind of orientation. So the next thing in your packet basically is my kind of macro view of how do we deal with technology, because that's what we're talking about. Okay? Technology is what's driving all kinds of things in our life. I appreciated Chief Smith's comments about things like OnStar and that sort of thing. And I appreciated Representative Holberg's comments that those are choices we make. But we don't make a choice when we buy a car to have an event data recorder in our car. Okay? How do we get event data recorders? Because the federal government mandates them. Now, did you all agree that that's the kind of thing we all ought to have in our cars? And do we all understand that we're paying for them? And the answer is probably not. So if you follow down the track that says on the handout that technology is adversely affecting our privacy, what do we do about it? And if you look over on the left side at the bottom, you'll come to, we almost always come to making the law. Okay, making a law. And I've been watching you do that, as I said, for 4 years. Okay? And as you heard earlier, one of the things that's happening right now is we have judges saying, I can't handle this technology stuff. And they're saying, you need to do this. Okay? And frankly, I think it's better that you do it than judges do it, based on some of the cases that I've read. So, what kind of things can you do if you want to start expanding your mind? And that's the next thing, which is a clipping about the federal watchdog says that the NSA program is illegal and should end. After years of the federal government kind of chasing its tail and saying, we have to do something about privacy, we have to do something about privacy, somebody finally established a Privacy and Civil Liberties Board within the government that looks at things like what the NSA is doing and says, I don't think this is legal and we ought to do something about it. That's the kind of thing I hope you start thinking about. And why do we, in the final analysis, why do you have to think about it? And that's the last handout. And that's from a dissent that Judge Brandeis wrote in a case called Olmstead, in which the part that's most often quoted is the part that says privacy is the most precious of human rights, because it's the right to be left alone, etc. But the quote I gave you is the part where Brandeis says, we have to be most careful when we look at what people are doing, particularly what the government is doing, not to worry about the super bad guys, because we'll recognize who the bad guys are. What we have to worry about is the good guys who are trying to do good, but somehow lose control.
Mr. Gemberling, please conclude your remarks.
I'm going to do that right now, sir. So, as you deal with this stuff, I would submit to you the way you try and deal with it is not necessarily the best way you can do that, because you're going to have a 2-hour hearing in which you just heard I have to truncate my testimony which is reasonable for the chair to do. But unless you find some better tools to take this stuff in and work with it, you're gonna find yourself coming back over and over and visiting the same issues over and over because technology is gonna change. And what do I think is a better tool? Well, Representative Holberg has got its legislation in to essentially establish a legislative commission on information issues. And I commend her legislation to you highly, because what you need to do is to have the ability to acquire information, to use the experts that you have available to you, to sit down with people like law enforcement and to help them understand how you want to balance the issues. And I would submit to you, unless you have that on an ongoing basis, you're going to continue to have problems, and you're going to continue to keep coming back to the same issues over and over, because technology is always going to run ahead of you unless you find a methodology to get ahead of technology.
Well, thank you very much for your testimony, Mr. Gemberling. Rich Neumeister. I would note, as Mr. Neumeister takes a seat, that members, I anticipate that there will be other opportunities this legislative session to have ongoing policy discussions of the type that have been highlighted by Mr. Gemberling, and no doubt will be highlighted by Mr. Neumeister as well as other testifiers. Is Professor Nikina Levy-Pounds here in the room? Because she was who I was going to call upon next. If she is not here, I would ask, please, on deck, Beth Frazier. Mr. Neumeister, please keep your comments limited to 5 minutes.
Mr. Chairman, members of the Civil Law Committee, my name is Rich Neumeister. My background is I have a degree in sociology and political science. I am from Hamline University. I'm someone who has, for many years, worked with policymakers, legislators, to help develop policy on privacy and open government and surveillance issues. And number 3 is that some of the people, commissioners and governors, have appointed me, and the state senate over the years, to various commission boards to do these kinds of issues. So where I come from, in the short way, because it's been truncated, is let's just go with what some of the testimony has been talking about. First of all, in terms of the BCA and that whole issue, the thing is that law enforcement has always had a long trend of secrecy. They just don't want to share information. I have done hundreds of data practices requests over the decades. And I've done a number of them on law enforcement. I'm getting some stuff, sometimes some things I'm not getting. I don't even know who the name of the company is that the BCA has an arrangement with, or a contract with, or a non-disclosure kind of thing. The thing is, it's all in the details. The thing is that let's go back and why the historical aspects of this. And I'll just go back 10 years. How many people remember NJNO, the Multiple Jurisdiction Network Organization, where down in secret, the Police Chiefs Association, it wasn't known to you guys, or the public at large, collected millions of records on hundreds of thousands or millions of citizens from northwestern Wisconsin and the Twin City area. Number 2, GangNet. Mr. Chairman, you're very familiar with Ramsey County. A lot of people didn't know about it. And you already know about the 2 other things that have been talked about. LPR took 4 years because the legislature knew about it. And mass people knew about it. Stingray, 8 years. And even in Hennepin County, it was talked about a little bit, but it was talked in, from my aspect, not a lot of information available. So the whole aspect of secrecy. And when we talk about administrative subpoenas, I have looked at hundreds of court orders and administrative subpoenas for the last 2 years. I get some, I don't get some. There's no consistency. But I can tell you, at least by looking at the face value of administrative subpoenas, text messages are going out to people. Email messages are going out. Our law 626A, which I've helped develop from 25 years ago, the new amendments to it, is number 1, is that it allows for over 180 days, certain things. GPS location data is being garnered by administrative subpoenas, which is a piece of paper, which is a very low threshold, a little bit over 100. Number 2, court orders. Again, it's relevant to the investigation. It's not a search warrant. Now, and that differs with the testimony by the BCA, and it varies from all over. Let's talk about cell phone extraction devices. These are things that are bought at again, there's lots of devices and some of them have been talked about, facial recognition. I've made data requests on some of them. Some I get pushback, some say none of your business, some say it helps with deliberative processes and we're not going to tell you. But I still get eventually some stuff. But the point is, say cell phone extraction devices. These are $3,000, $5,000 little things that law enforcement has gotten. And what brought my attention to it was in the mid-2005, when people were telling me, particularly in communities of color, and some people who are arrested, that they are arrested, and what happens, they get their iPhone, smartphone, cell phone back, and it's all created, they don't know what, it became discombobulated. And so what's happening to some extent, again, through my data request, I'm finding different standards within law enforcement. You need a search warrant. On some agencies, you don't need a search warrant because they say based on incident to arrest. And
please conclude your remarks.
Okay, and so what's happening within that information? Then I just want to say, at least in a final kind of comment. Mr. Chairman, law enforcement will tell you different things. I've dealt with law enforcement for a number of years. And I go back to an incident in 1989 that I found out that law enforcement was using a basic radio scan, going up and down the streets of St. Paul and Minneapolis, listening to people's phone conversations. And this is, if you remember, the old cordless radio thing. Now, law enforcement and all these new technologies are not going to knock on your door, Mr. Chairman, and say, hey, we can have these new toys, which are beneficial, I'll admit, but we got to come up and update our laws. No. I found out about that. And other things I've found out over the decades that I've been here. And I've gone to policymakers like you, Mr. Chairman, in a bipartisan way, and you've changed the law to make sure that our liberties and our privacy interests are balanced. And this is the case that I see where I think it's important for you now to grab a hold. This is the third time in almost my nearly 40 years that I see a broad general oversight hearing like this. So take the opportunity to involve yourself on these issues. There are facial recognition, LPRs, they're coming down the stream. And I just share with you one perspective, and when I leave you a thing, because this is a duty or a job. I have gotten, like the Mobile Plane Hunter LPR Car Systems User's Guide. This is what's given to law enforcement. Now, on LPR, and I only use it as an example, they say our basic concept is for stolen license, for stolen cars. But the manufacturers are talking a lot about a lot more other things, and a lot of law enforcement entities here in the state of Minnesota are using it for those kinds of ideas. And Mr. Chairman, in your comment on PR yesterday, you said something like, what's the next tweak that they're going to use to enhance? Well, it's happening constantly. And and the last point that was made is...
You made your last point.
They're starting to connect things. So, Mr. Chairman, I want to thank you very much. For the first time in thousands of times that I've been before the legislature on bills and amendments, I've never gotten a letter to invite me. So at least, Mr. Chairman, I'm recognized by you and your committee at least having something little to say, something little to say to help make good privacy.
Was you a certificate?
And liberty law. Thank you.
Thank you. Beth Frazier. Please introduce yourself for the record. Ms. Frazier, if you could please keep your remarks limited to 3 minutes. My apologies.
Yes, thank you, Mr. Chair and members. Beth Frazier, Deputy Secretary of State. And our office, the Secretary of State's office, runs the Safe at Home program, which is for survivors of domestic violence and primarily of stalking, people who are in very dangerous stalking situations. And I want to especially thank you, Mr. Chair, and Representative Holger and Senator Dibble for your work on helping us protect the privacy of people in this program and who are in very serious, dangerous situations and thinking about their privacy needs. And we have a lot of concerns about the technology that can be used to track citizens' locations, and particularly the locations of participants in this program. And we're relieved that the license plate reader data is at least temporarily deemed private. which means that it's not accessible to anyone and everyone. But while the vast majority of people in law enforcement are law-abiding and very helpful to our society, there are a few bad actors, and there are people in our program whose stalkers are in law enforcement. And so we still have concerns, even with the data being private, because law enforcement still has access to it. And we have questions about who has access to this data and under what circumstances. And we either need to ensure that the data of everyone who is not a hit is immediately destroyed, which would include people in the Safe at Home program, or we need a way on a statewide basis for participants in Safe at Home to ask to have their data destroyed immediately. And so we've been in conversations about that and are looking forward to the legislature taking action so that they either protects all citizens' private data unless there's a hit, or at least the Safe at Home participants' private data. So I'm happy to answer any questions, and thank you for your time and your attention to this matter.
Thank you for your testimony, Ms. Frazier, and we're going to hold off on committee questions for you now because we only have a couple minutes left of committee time. Members, we will be having subsequent session hearings on this topic. I imagine we may be doing it with Senator Dibble because of his interest in this area as well. That said, for those who came here in the hopes of testifying as members of the public, I want you to know that there will be opportunities for you to do so in a subsequent hearing. I apologize that we don't have time to do that today, but today's primary committee function was oversight. In light of that, in light of the invitations and letters that we sent out to members of the law enforcement community, I wanted to give an oral opportunity, in case individuals are here in the room who were invited. Is Anoka County Sheriff James Stewart here? Anoka County Sheriff James Stewart. Dakota County Sheriff Dave Bellows. Dakota County Sheriff Dave Bellows. Now let's begin. Hennepin County Sheriff Rich Stanek. Hennepin County Sheriff Rich Stanek. I would note after calling Mr. Stanek's name, Sheriff Stanek's name, that he did have the courtesy of giving me a call and telling me he wasn't coming. That said, Sheriff Stanek is one of only 2 agencies in the state that employ the use of cell phone exploitation devices. And the committee is without information on how his agency operates it in order to proceed with any policy changes we make at the state level. That is a glaring omission in information that the committee has at this point. And in keeping with no information from the other agencies who responded, I guess I would echo Chief Harteau in saying, well, now we don't know what we don't know. Olmstead County Sheriff Dave Mueller, thank you for being here. Ramsey County Sheriff Matt Bostrom. Ramsey County Sheriff Matt Bostrom. St. Louis County Sheriff Ross Littman. St. Louis County Sheriff Ross Littman. Scott County Sheriff Kevin Studnicka. I hope I didn't butcher his name. Scott County Sheriff Kevin Studnicka. Stearns County Sheriff John Sanner. Stearns County Sheriff John Sanner. Washington County Sheriff William Hutton. Washington County Sheriff William Hutton. Wright County Sheriff Joe Haggerty. Wright County Sheriff Joe Haggerty. Rochester Police Chief Roger Peterson. Rochester Police Chief Roger Peterson. Duluth Police Chief Gordon Ramsey. Duluth Police Chief Gordon Ramsey. Bloomington Police Chief Jeff Potts. Bloomington Police Chief Jeff Potts. Seeing no one come forward from a policy position, we will consider these individuals to have refused our invitation to testify. Members, The committee will take under consideration in a subsequent hearing whether or not we choose to compel testimony. Are there any last questions from members of the committee before we conclude? Representative Holbrook.
Thank you, Mr. Chair. I think we do need to note, you stated that there were just 2 agencies in the state using these technologies. I think there are also federal agencies using these technologies within our state border, which is a whole other can of worms.
That's a good point, Representative Holbrook. Thank you. And at this point, without that information, we don't know. There could be other agencies as well, just beyond the federal, but they haven't shown up to testify as the question, so we don't know. Any other questions from members of the committee? Okay, that being said, thank you. There being no other business before the committee is adjourned.
If I end up on YouTube, I'm going to be upset.